tampering. The defendant subsequently terminated the claimant's employment, which the claimant alleges was done forthwith without notice or reasons, while the defendant maintains terminal benefits were processed. The defendant also asserts that the claimant has accepted terminal benefits and payment in lieu of notice following the termination. During cross-examination on January 28, 2025, the claimant admitted that he signed his witness statement on oath dated June 25, 2024 at his lawyer's office rather than be before a commissioner for oath. Trial in this suit commenced with the claimant testifying on behalf of himself and tendering the following exhibit. They were admitted and marked as exhibit C1 to C10. They are all listed in the body of the judgment. The defendant opened its case with one Enwemike Ifani, a human resource assistant senior clerk, testifying on its behalf. The defendant tendered a total of 10 documents which were admitted and marked as exhibit D1 to D10. The details of the exhibit are all in the body of the judgment. I also have the defendant's final written address, and I have the claimant's final written address, all embodied here, and all the issues raised. I'm going to the court's decision. So there is a preliminary issue this court will address before going into the depth of its suit. The learned defense counsel submitted that during cross-examination on the 28th of January 2025, the claimant admitted that he signed his witness statement on oath at his lawyer's office, not before a commissioner for oath. The defendant argues that such admission offends the Oaths Law, Section 112 and Section 117 of the Evidence Act and Section 19 of the Notary Public Act, and the witness statement on oath, which is his evidence in chief, should be expunged from the court's record. He argued further that signing a document before presenting it to the commissioner for oath for endorsement is a fundamental defect that amounts to deceit and perjury. After cross-examination, the claimant on the 10th of April 2025, in a bid to set the record straight, filed an affidavit of fact that the claimant's witness statement on oath was signed at the registry of this honorable court, and attached was an exhibit, which was the certified copy of proof that he was physically present in court and signed his witness statement on oath, effectively debunking the insinuation under cross-examination that the statement was signed in the counsel's office. The claimant further argued that since the defendant did not file any counter affidavit to challenge or controvert this fact, the affidavit of fact must be acted upon by the court and given full probative value. He cited Shell Petroleum, GC, and Olarawaju, and AG, Federation, and Abubakar. Citations were all provided. On this issue, the position of the law is that prior to adoption, a witness statement on oath is merely a proposal by a party of the evidence they intend to call at the trial. It does not become evidence that a court can rely on until it is adopted by the witnesses. Sani and Ishaku, 2022, Law Pavilion Electronic Law Report, 57479, Court of Appeal. The Supreme Court, in a recent case of Katagu versus Oma, 2026, Law Pavilion Electronic Law Report, 83085, Supreme Court, provided a definitive clarification on this matter. The court held that, and I quote, when a witness in open court takes oath as a witness and adopts his or her written statement of relevant facts, sworn or not sworn, the written statement ceases to exist as a witness statement, as a witness written statement, and transforms into the witness oral evidence in examination in chief, upon which the witness can be cross-examined. This admitted oral evidence on oath cannot be expunged as evidence on the ground of any defect in the written witness statement precedent to it, per Emmanuel Akumaye Agim, JSC. This pronouncement from the Apex Court is pivotal. It establishes that the act of a witness taking an oath in open court and subsequently adopting his written statement, even if that statement was initially, and I quote, not sworn, or had a defect in its swearing process, regularizes the evidence. The written statement upon adoption transforms into the witness oral evidence given under oath in court. Consequently, any initial defect in how the written statement was sworn or not sworn before the commissioner for oath becomes irrelevant for the purpose of expunging that evidence. The evidence having been adopted under judicial oath stands as valid oral testimony. This position aligns with a new trend in the administration of justice, which seeks to prevent technicalities from overriding substantial justice. Say Abubakar and Ali, Citations are provided. While the initial defect in swearing a written statement on oath is an irregularity, the subsequent solemn act of taking the judicial oath and adopting the statement in open court cures that irregularity, transforming the document into admissible oral evidence. In view of the Supreme Court decision above, the argument of the defendant in paragraph 4.1.0 of his final written address is overruled. The claimant has valid evidence before this court, and I shall proceed to determine the matter accordingly. I so hold. Now, to the relief sought, the claimant is seeking a declaration that the termination of the claimant's employment without notice or reason is unlawful. The state of the law in respect of the grant of declaratory reliefs are clear. Declaratory reliefs being discretionary in nature, the applicant bears the burden of satisfying the court of his entitlement to same. An applicant must therefore adduce sufficient, cogent, and credible evidence in support of his claim. In fact, declaratory relief is not even granted on admission of the other side. Thus, an applicant for a grant of declaration must either succeed or fail on the strength of his case. See Adamu and Nigerian Air Force citation provided. The case of the claimant is that he took the truck assigned to him for general servicing to the company's yard in December 2023. And while he was there, he received a phone call from the trafficking device had been tampered with. See paragraph 7 to 8 of the statement of fact. When he reported to the security office, the security officer wrote a statement and he was asked to sign. This was after he explained he knew nothing of the allegation and that other drivers had used the truck in his absence, and that may be where the problem arose from. The claimant averred that he sought the intervention of the transport supervisor and union chairman in line with the condition of service handbook, but it was unsuccessful and his appointment was thereafter terminated. Claimant argues that he was denied fair hearing due to defendant's failure to issue a valid notice of termination and failed to communicate his termination benefit before his termination. Furthermore, that the misconduct was not established by credible, cogent, and convincing evidence. That during cross-examination, DW1 admitted that the claimant was not the only driver of the truck. Other drivers had access to the truck, especially when the claimant was on leave, and that those drivers were never called for questioning. Finally, the data of termination was never communicated to him, neither was there proof of service on the claimant. In all of these averments, parties are in agreement that the claimant was invited to the office and he made a written statement on the 7th day of December 2023, exhibited as D4. The case was referred to the Central Investigation Unit, in brackets CIU. Parties, however, hold divergent views on the investigation report. The defendant maintains that the claimant was not on leave as claimed and relied on the time card for the month of November and December 2023, Exhibit D6, while claimant is relying on his medical report of 27 April 2023 to establish that he was off duty, Exhibit C2, at the time. And besides, when he resumed and found a dent on the vehicle, he informed his supervisor and tendered the picture showing the dent on the truck. When he resumed from medical leave marked as Exhibit C3 in April 2023, claimant also relied on the fuel card, which had 3 signatories to show that other drivers had access to the truck, which occasioned collecting fuel. The court noted that during trial, the claimant, having pleaded and tendered the above-mentioned exhibits to establish the fact that different drivers had access to the truck in question, especially the fuel card, which shows that the 3 signatories got fuel in April 2023, the report Exhibit D5 was silent on whether the other signatories were questioned about the tracker tampering allegation. Again, the dent which claimant discovered and reported to his supervisor was in April 2023, while the tampering with the tracker was discovered in December 2023 during routine maintenance/service. It is the finding of this court that the final report of the CIU did not extend its dragnet to the incidences that took place in April 2023. Rather, it concentrated on the timeline of November to December 2023, Exhibit C6, as the period when the tampering device occurred. On the issue of fair hearing, again, the court noted that the termination was indeed triggered by an allegation of misconduct, tampering with tracker device, and the defendant was obligated to provide the claimant with an opportunity to defend himself before a disciplinary committee. The defendant tendered Exhibit D4, which is the claimant's written statement dated 7th of December 2023, and Exhibit C5, which is the report of the disciplinary inquiry dated December 11th, 2023. The report is, however, silent. If the claimant fails the CIU, the report stated, and I quote, "On receipt of the report, Mr. Ibrahim Adepoju, tally number 10 35501 was invited to the investigation office Ijora, where he was interviewed and a statement was obtained. End of quotation. On the other hand, DW1 in paragraph 9 averred that the incident was referred to the CIU in accordance with the disparate practice for junior staff, and claimant made the statement of 7 December 2023. And in paragraph 10, DW1 stated that the claimant was afforded an opportunity to explain himself and tendered the report marked as D5. It is obvious that parties have different conflicting versions and sequence of events on how the process of investigation took place. Be that as it may, it is the finding and holding of this court that the invitation to Ijora office to write the statement, which was tendered by the defendant and marked as D4 without opposition, suffices as giving claimant an opportunity to defend himself. See Amonike versus Unity Bank, citations are provided. The court, upon examination of the condition of service handbook, noted that there was no prescribed layer of disciplinary conduct. Therefore, the statement of the claimant tendered as Exhibit D4 fulfilled the requirement of fair hearing and gave the claimant an opportunity to be heard. I so hold. It must be noted that while the defendant possessed the inherent right in Article 9 of Exhibit C6, which is the staff condition of service handbook, to terminate the contract of service, during trial, DW1 testified that the termination notice was served through a timekeeper but failed to tender the acknowledged copy to the court. Under Nigerian employment law, failure to issue a termination letter is not automatically fatal to the termination, but it can create serious legal problems for the employer depending on the circumstances. It is strike law that termination doesn't have to be in writing to be valid. At common law, an employment relationship in Nigeria can be terminated orally or by conduct, provided the employer complies with the terms of the contract, especially notice requirement or payment in lieu of notice. Courts have held that what matters most is whether the employer followed the contract, not necessarily whether a formal letter was issued. It must be noted, though, that failure to give a termination letter can make the termination wrongful, even though it is not automatically void. The absence of a termination letter can make it difficult for the employer to prove that proper notice was given. Create uncertainty about the effective date of termination, suggest lack of due process or fair treatment. If the contract requires written notice, which must do, then failing to provide it can amount to wrongful termination, entitling the employee to damages, usually salary in lieu of notice. The court is not unmindful of Section 11 of the Labour Act, which mandates minimum notice periods for the termination of contracts of employment ranging from 1 day to 1 month, depending on the length of service. This applies to the claimant as a confirmed tipper driver to ensure he is not terminated without warning, since the defendant terminated the claimant following a security statement made 7th of December 2023 without a formal hearing or notice. The defendant can be said to have breached the contractual and statutory requirements, making the termination wrongful in law. While the claimant is seeking a declaration that the termination of the employment without notice or reason is unlawful, the court noted that the claimant used the word unlawful. In Nigerian labor law, the distinction between unlawful and wrongful termination is critical. As established in Ikemba and Pyramid Company Limited citation provided, the claimant's use of the term unlawful is generally reserved for employment with statutory flavor. In Court of Appeal in UBS versus Chinyere, citations also provided, the court defined wrongful termination and held, and I quote, "An employment can only be said to have been wrongfully terminated if it was done contrary to the condition governing the particular contract of service or manner not contemplated by the conditions of service." End of quotation. While the claimant alleges the termination was based on a false allegation of tampering with a tracking device, in a pure master-servant relationship, the motive for termination is often irrelevant unless the employer provides a reason, in which case the employer must justify that reason. However, if the defendant exercises its right to terminate by giving notice or paying in lieu, the termination is not wrongful. The defendant in paragraph 13 and 14 of the statement of defense, however, stated that the termination benefits due to the claimant was paid inclusive of the sum of 80,277 naira 12 kobo, being 1 month basic salary, being payment in lieu of notice in accordance with the conditions of service for junior staff, and also 359,000 naira 939 naira 26 kobo, comprising severance ex gratia and salary for February 2024 was paid. The payslip for February 2024 and proof of bank transfer was tendered as Exhibit D9 and D10 respectively. In Moron Fuller versus Kwara State College of Technology, the Court of Appeal held that the payment of the salary in lieu of notice to the bank of the employee where his salaries had ordinarily been paid to will be sufficient compliance with the terms of the contract relating to payment in lieu of notice. As was the case in Ajayi versus Texaco Nigeria Ltd, citation provided the letter of termination of an appointment might also inform the employee that salary in lieu of notice and his other entitlement would be paid to him and the actual payment made thereafter. This averment was never controverted by the claimant throughout trial. It is therefore deemed admitted and need no further proof. I so find and hold. Another issue that needs to be addressed is whether the claimant is stopped from challenging the termination after accepting terminal benefits and payment in lieu of notice. The position of the law is that by accepting the terminal benefits and the payment in lieu of notice processed by the defendant, the claimant has effectively waived his right to sue for wrongful termination. The law views the voluntary acceptance of such payment as an election to treat the employment contract as lawfully terminated, allowing the claimant to retain the financial benefits of the termination while simultaneously seeking damages for the same act would be inequitable and contrary to established legal principles. Consequently, even if the termination procedure was initially flawed, the claimant's subsequent conduct in accepting the benefit has cured the defect and finalized the severance of the relationship. The principle of estoppel by conduct, specifically the doctrine of election, is a potent defense in employment litigation. It is a well-settled principle of Nigerian law that where an employee accepts terminal benefits or payment in lieu of notice upon the termination of their employment, they are generally deemed to have acquiesced to the termination and are stopped from subsequently challenging it as wrongful. This principle prevents a party from appropriating and reprobating, accepting the financial benefits of the termination while simultaneously seeking to invalidate the act of termination itself. In Dangote 7 PLC and AGA, citations also provided the Supreme Court reinforced that the voluntary acceptance of such payment signifies the employee's election to treat the contract as lawfully ended. The court knows that Section 169 of the Evidence Act also provides for estoppel by conduct, stating that where a person has by his act permitted another to believe a thing to be true and to act upon that belief, he cannot deny it. This applies here because the defendant paid the benefits believing the claimant accepted the termination. The Nigerian appellate courts have consistently applied this in employment cases, notably in Gerawa and in Babura. Citation provided per Abba Aji, JCA, and Julius Beda versus Nwaliwu. Citations also provided where it was held that an employee who collects terminal benefits cannot later turn around to challenge the termination of his appointment. In this case, the evidence demonstrates that the claimant Ibrahim Adepoju received without protest and utilized the terminal benefits and the month's salary in lieu of notice provided by Julius Berger Nigeria PLC. He is therefore stopped from maintaining an action for lawful termination, and his right to sue for wrongful termination is extinguished as he cannot enjoy the fruits of the termination and still claim the termination was a legal nullity. It is the holding of this court that by receiving the payments, the claimant signaled his concurrence with the end of the contract, and he is now barred by law from asserting a contrary position in court. This is the finding of the court. I so find. In view of the above findings and decisions, relief one fails and it is dismissed. The second relief is for an order directing the defendant to pay the claimant all his salaries, allowances, and or other perquisites accruable to the claimant from the date of the purported termination until judgment is delivered. While the third relief is for 10 million naira being special and there are damages for wrongful termination of the claimant's employment. It is right that salaries, allowances cannot accrue to a terminated employee. There was no evidence before this court that claimant discharged his duties after the date of termination, having received all his terminal benefits. This court hereby dismisses this claim under relief 2. The employer cannot pay for work not done. I so hold. The law is also settled that claims for special damages must be specifically pleaded and strictly proved. Special damages are those losses that the law will not infer from the nature of the act complained of. They are exceptional in character and must have crystallized in terms and value before trial. Failure to specifically plead and strictly prove special damages will result in their non-recovery. CSCN versus Samuel, citation provided. Similarly, Menham and Imperial Homes Mortgage Bank Ltd. Citations also provided, which reiterated that, and I quote, the law on claim for special damages is that it must be specifically pleaded and strictly proved. Where it is not so, recovery of the same will not be granted. Every item contained in the claim for special damages must be specifically proved, and such proof must be characterized by testimony that ties each item with the evidence led. End of quotation. The Court of Appeal in Access Bank versus Sadu, citation also provided, emphasized those special damages, and I quote, cannot be inferred by the circumstances of the case, end of quotation. General damages, in contrast to special damages, do not require specific pleading and strict proof. General damages are presumed by law to flow naturally or accrue from the wrong complained of, either directly or proximately. In Anene versus MTN, citation also provided, the Apex Court explicitly stated that, and I quote, it would be a fallacy to argue that the award of general damages must be strictly pleaded and proven in evidence. The law presumes general damages to flow naturally or accrue from the wrong complained of, either directly or approximately, end of quotation. The award of general damages is at the discretion of the court to be exercised judicially and judicially. As earlier found in this judgment, the claimant is in receipt of payment in lieu of notice as exhibited in Exhibit D9 and D10. In the circumstance, this court declines the grant of the relief sought for general damages. The cost of legal representation in the sum of 800,000 and cost of the suit in the sum of 300,000 is dismissed for lack of foundation to base the claims, since the principal relief had failed. Judgment is accordingly entered today, the 20th day of May 2026. This is the judgment of the court.
My Lord, we are most grateful for a well-considered judgment. We thank your Lordship for the industry.
My Lord, we are grateful for the well-considered judgment, even though it's not in our favor.
Okay, thank you.
Yes. We wish my Lord a restful day. Thank you.